Committee. First time in 2022 that we're meeting. We're again meeting remotely. And all committee members are here. And we're joined by our 3 members of Legislative Council, as well as our committee assistant, Peggy Delaney. So with that, I got to click that I got it. The meeting is being live streamed. I do know that now. We had a number of bills referred to us, but our first priority is the bill we've been working on regarding some amendments to the raise the age and youthful offender statutes. And that will take up most of tomorrow and Thursday, my guess. What's left of Thursday? You have a joint meeting with the House and Houses. No, we don't.
It's Wednesday.
Tomorrow's Wednesday.
Wednesday is the joint meeting with the Senate and Thursday is joint meeting with the House.
Right. It's a noontime meeting tomorrow with the Senate Institutions Committee.
Oh,
And that's to discuss whatever plan there is for kids that used to go to Woodside.
Good.
I thought you meant the State of the State address, which is Wednesday.
No, but we do have on Thursday, we have a meeting with the House Judiciary Committee and House Corrections and Institutions Committee on the report on Justice Reinvestment 2. Particularly focused on the racial disparities findings of the Justice Center.
Is that during our committee time, Dick, or is that at noon?
That's during our committee time. It's from, what is it, Peggy?
10:30 to 12.
10:30 to 12. So we'll meet from 9 to 10:15 or so. Take a break and come back and meet with them jointly.
Thank you.
Remotely, of course. But tomorrow will be during our lunch hour. Eric has sent out the drafts, and I don't know if he's gotten much response on the raise the age youthful offender bill. I think we're in pretty good shape.
Yeah, no responses yet, Senator Sears, but I think maybe people will testify tomorrow.
Yeah. Yep. Well, times are waiting. So other than, yes, Senator Nick.
With regard to raise the age, do we have a version of it from when we last met, Eric, or is this a totally new draft?
This is new based on the discussions that the committee had last time. So this is totally, the changes to the previous draft are highlighted in yellow.
Okay. Thank you.
You bet.
I met with Representative Grad and we kind of divided up who would take the lead on what. And Michelle was kind enough to print it, to give me a copy. Unfortunately, when I printed it out, it's so small that I have to put my glasses on to see it, but that was my printer that did that. The House is taking the lead on a victims compensation fund, the sealing or expungement of history records, and drug reclassification and child marriage. I don't know what that is. And miscellaneous cannabis, but and those are all Michelle's bill. Then they're taking the lead on forfeiture, which is Ben's bill, crime reclassification, which is their favorite subject that we've talked about in here after they pass it. Uniform POA is Eric's. Miscellaneous judiciary, they're going to start this year because we started last year. There's a judicial nominating board, some changes there. Eric has that. And then we have the Bureau of Racial Justice Statistics, which we worked on last year, but to some extent, but they never passed the bill. And then they've got firearms that they have was it S33?
S30.
S30. And we've talked a little bit about that. I don't know when they'll do it, whatever, but they will take that up. No, we agreed to take up the self-defense, or it's really, Eric, the justifiable homicide statute. Senator Benning is the lead sponsor of the bill that was introduced today. We've agreed to take that up. We've agreed to take the raise the age, which we just talked about. The midpoint probation review. There is a bill on probate guardianship that I committed to take up. That's Cheryl Hooker's bill. That her neighbor has had umpteen problems with guardianship. I really think his issues are genuine and need to be addressed. Those rules haven't been updated in hundreds of years. Well, I don't know. I shouldn't say hundred. Long time. Then we have qualified immunity that we will look at. Criminal threatening, which is, and then medical cannabis, but that actually went to health and welfare this morning.
Yeah, Senator Sears, can I just mention something on that one? Part of the reason why y'all were going to start with that was to move it quickly, because you might recall that when you passed the initial commercial legalization, you set up the medical statutes to be repealed on March 1st, and new ones in effect, assuming that the new rules would be in effect, and none of that's going to happen. So the legislature needs to pass this tweak to that's in the medical cannabis bill before March 1st, or you're going to have no medical laws.
But now it's not in judiciary. So health and welfare has to take it up.
Okay, I wasn't sure whether or not that was just a mistake that it went there, since they always come to you.
I don't know. I expected the small farmer bill to go to agriculture, but I didn't expect the medical bill to go to health and welfare, but it did. And so it's up to Senator Lyons. And I don't know. I mean, we can send her an email if you want to prepare that for me.
Sure.
With the urgency on that piece of it. If they don't do anything else, they need to do that most days. But I was planning on having the bill.
Right. Yeah. I just want to make sure that little piece didn't get lost, because I don't think it's anybody's intention to not have any medical laws for a while.
Well, yeah, our best laid plans get waylaid sometimes. So, I mean, I guess the good news is we don't have to deal with cannabis in judiciary.
So the House sends you the miscellaneous judiciary cannabis bill.
Oh yeah. I just, you make plans for what you're going to take up, and you do your best. It just happens. If we just provide a memo to Senator Lyons on the importance of getting that piece out as quickly as possible.
Senator Sears?
Yes.
So I was looking at the bills that came here today, and I would, you can't see the text of them yet, so I don't know what this actually says, but S-163, which is the special juvenile immigrant status, I thought we dealt with that already.
I thought we did too.
I don't think it went all the way.
I think the House.
You mean they didn't do it?
I don't,
No,
don't
I think
think-
it did. Sorry to interrupt, but I think it did pass, but there's some tweaks to it.
Oh,
I didn't draft it, but I heard about it. It's not that the original bill didn't pass. It did pass. And you're right, Senator White, you did pass it out of this committee. but I think there's some proposed tweaks to the existing statute.
Oh, okay, thanks.
Is that a rather simple tweak? Who drafted it?
It was Becky Wasserman. I'm not familiar with the substance. I just knew the general
Okay.
idea.
I was surprised that legislative subpoenas came here. I thought it was going to go to government operations.
What one was that? Do you know the number?
S-150. What it does is allows committees to subpoena people during the interim. Right now, it needs a majority of the Senate. If it's a Senate committee and if it's a joint committee, it needs a majority of the General Assembly in order to subpoena somebody. And we were having some trouble with some members of the administration at one point. They got ironed out okay, but it seemed to me as a gap where the legislature can't do anything if somebody refuses to come and testify unless they get.
Oh, I'm sorry. I thought you were done.
Go ahead.
So would this say in the off session that a chair on their own say so could subpoena?
No, I believe the bill, you can correct me if I'm wrong, my recollection of the way we introduced it, it would be a majority of the committee would have to vote to approve a subpoena.
That
Would-
seems
would-
a little like a 5-member committee. That would really be very few people
Yeah.
signing off on that.
Is that just for standing committees or for joint
Could be a
committees or
joint-
oversight
could be a joint-
committees?
Could be an oversight committee, could be a joint committee.
Because we don't actually meet during the summer. I mean, normally.
Well,
Okay, I haven't read it, so.
well, it's, the idea is that we're up against it when somebody refuses to testify. The only time I've seen it actually done was during the Carringer investigation. And in the resolution that created the special Senate committee, which I was on in my first term, they provided for the subpoena. And he had died at the St. Albans Correctional Facility, and there were a number of allegations about conditions at St. Albans. This is in the 1990s, so it was a long time ago, but it allowed for subpoenas because the correctional officers and others didn't want to testify when the institutions committee began looking at it. Anyway, that's the bill. If we take it up, certainly we'll look at all that and see how to deal with it. But you're really lost during the off session when there's no power to do anything. And for example, Joint Oversight Committee on Justice Oversight had somebody they wanted to talk to, and that person refused. There's nothing they can do.
Was it somebody from the administration?
It was potentially at that point, yeah. When I first asked Eric to draft it.
How do you have that set up, Eric? Is that issued by a specific committee member? And normally subpoenas are issued by a judge, a clerk, or an attorney. I'm curious as to what the launch pad would be for getting that out the door.
As Senator Sears indicated, Senator Benning, that actually was drafted by our government operations attorney because that's where it's located in the statute. So I just looked at the language. I didn't see that issue. I didn't draft it myself, but I just took a peek at it. And it's sort of a general authorization for, as Senator Sears said, by a majority vote of the committee. It doesn't speak to the mechanics of the process.
I know that the court forms would have to be brought into alliance with whatever is done, because the subpoenas themselves are on the judicial forms website, and I don't know how we would dovetail with that, but it's a curious question.
I think,
Yeah,
and maybe Michelle will remember this, I think the legislature can issue its own subpoenas and has done so in the past and does not rely on the judicial forms.
Yeah.
True, we
it
did,
just-
I think
Oh,
the
go ahead.
last one I did, maybe the only one I did, I think I've done a couple, but I think the last one I did was when, and Senator Dicka may remember this, when Judge Keller was up for retention, and there was a witness who I think we issued a subpoena for testimony. Bring that correctly, I think we,
Are you thinking of when we got some information from the Judicial Conduct Board? Did that person?
I thought it was during retention with Keller. I thought somebody had information, but they didn't really want to come forward voluntarily. They
I
wanted,
think a member
you know,
member of the Judicial Conduct Board. I don't know that we got a subpoena in the end, but they were hesitant to put their documents forward without some protection, I think.
right. We
Might
had
have been a
also looked
subpoena
at
you
it
could
during
take it.
the Jake's hearings that Senate Judiciary did
Yep.
as
Yep.
well. So there is authority, and it's been so long since I worked on it, I don't recall the mechanic, but
But I think in the resolution that set up the Jake's hearings, we got subpoena power from the Senate, but I don't remember that. You know, I'm not even sure we're going to take the bill up, so it's just something that I think we should be more aware of, the limitations we put on ourselves. We will take up the acrolein to defense of others and justifiable homicide. We are going to take up the midpoint review probation. That just corrects. I think everybody on the committee is co-sponsor the bill, and it corrects what I think was Judge Treadwell's misreading of what the legislation was intended to do. But another one of those Windham County things.
Oh my God, don't go there.
No. I want to take up the medical monitoring bill that was here from last year in light of the settlement between St. Gobain and the people in North Bennington. And I think that pretty much given the language that was in the settlement agreement that allows medical monitoring can be a guide for us. So hopefully it won't be as controversial as it was now that there's been a settlement reached, and I believe the parties have signed off.
Are we ever going to do anything with spousal maintenance?
If the House would. And we can keep passing the bill. I mean, at some point, you know, it seems counter. I mean,
Yeah,
we passed it 3 times, I believe.
yeah. I don't understand, but
Dick,
Are
I
there
just wanted,
Yeah.
I just wanted to remind you and Peggy, I remain on LCAR, much to my joy. That meets on Thursday mornings. And this Thursday is the first one of those, but right after that, I got to be in health and welfare for an introduction of the suicide prevention bill, and then I'll be in.
Okay. Well, we should be, we're starting at 9, so let's see how, I think it shouldn't take long. Are there other issues that people have that they really feel ought to be addressed?
Well, I did put in S-182, which is directed at paramilitary training camps.
Mhm.
And my reason for submitting that is the Slate Ridge situation, which remains unresolved. And the administration has a number of times pointed to the fact that they don't have any recourse in statute to allow them to shut the place down, even though there's plenty of testimony in the public record in the coverage of the situation that the neighbors are terrified of the people in the situation there. So I don't mean it as something that should drive the committee's agenda, but I do think it's something the legislature should be thinking about and trying to get a grip on.
What exactly does it do?
Well, it prohibits paramilitary training camps, distinguishing them from traditional shooting ranges and other authorized training situations. So it says if you have a place like Slate Ridge where you're training people using structures and vehicles and training them to attack those places and to develop paramilitary strategies, that is prohibited. And it gives, I think it's Department of Public Safety, a little bit of say-so in that instance. You know, there are many carve-outs in it to allow for the things that we all want to continue, but it prohibits those sorts of, you know, as distinguished from target shooting, training people in military tactics or the use of explosives, something that was also going on apparently at Slate Ridge. So, you know, it's a tricky area because traditional shooting ranges have very little regulation, and it's not my intent to regulate them with the bill. It's to distinguish those from what's happening at Slate Ridge, where you had someone advertising nationally, come to Vermont, learn how to use weapons and tactics in a military way to achieve paramilitary ends. And I think at this moment in time, that's something that we have to be cognizant of, and we have to decide how we feel as a legislature about it.
How would you distinguish them from regular training camps? I mean, regular shooting ranges other than by their advertising? And they would just change their advertising.
Yeah. Eric, I don't know if you have the wording in front of you, the definition for, I don't have it in front of me.
I can pull it up in a moment.
Okay. You know, it's, I think Eric did a great job drafting it, whether other people agree that it's a clear distinction. And it's never going to be as clear as you'd want, because traditional shooting ranges, people show up with guns and they shoot at different sorts of targets. But this is really trying to get at training in military tactics, the use of explosives, things where you're training people to think about how to turn guns on other people as opposed to targets. Or do you have that, Eric?
Yes. So as you were kind of getting at, Senator Baruch, the key is in how the paramilitary training camp is defined. Excuse me, and it's defined in the bill S-182 as basically defining paramilitary training means instruction designed to prepare a person for combat through the simulation of military training and tactics that involve stage or simulated attacks on buildings, vehicles, or persons, or in the use of explosives. So, and also as Senator Baruch was indicating, there's a fairly lengthy list of exemptions to that, so that that the definition would not encompass such things as training by law enforcement agencies, National Guard, U.S. Armed Forces, fire departments, active shooter drills conducted by schools, hunter safety, sports shooting at a sports shooting range. Those sorts of things are all expressly exempted.
So I know it's a knotty problem, and I know people would be of probably mixed minds about it, but it seems to me odd that the legislature would continue to not weigh in on that problem. And we left it ultimately to an environmental judge to deal with it, which is, I don't know, strikes me as a certain amount of cowardice on the part of state government.
Well, there's also an issue of who's my understanding is the investigators for the Agency of Natural Resources did not want to go there to enforce the Act 250 rules. The state police, I believe, Department of Public Safety, I could be corrected. My recollection is they didn't feel that they had any jurisdiction. So it's like everybody saying, well, you know, there's nothing we can do, even though they're violating Act 250, and that's how it got left to the environmental judge. I think I'm correct on that,
Yeah.
on the way it went, but it also showed a lack of coordination within the enforcement division of the Agency of Natural Resources, or at least they didn't feel they had the backup to go in there with their enforcement division.
So Phil, what are the consequences here? It's a prohibition for having one, but what are the consequences for having one?
Eric,
Because
do
the
you-
people who are going to run it aren't going to pay any attention to a prohibition.
Yep, understood. Eric, do you have that?
Yeah, it's a 1-year misdemeanor,
And that means,
1 year incarceration, 1 year in jail, and I think a $5,000. I can't remember if the fine is 1,000 or 5,000. But it's
So
it's a criminal
person-
prohibition,
Up to, right?
up to, right?
so the person that has the the camp would go to jail for up to a year or pay a fine, and the camp would continue.
Well, I don't think the bill right now expressly addresses the camp being shut down, but I would think if it's an illegal operation, they could shut it down. The administration, Department of Public Safety could shut it down.
I can understand the frustration about natural resources not feeling that they had backup on an alleged Act 250 violation. But when I heard you say that explosives were happening there, I'm pretty sure, and Eric, correct me if I'm wrong, that possession of an explosive device is a felony. And DPS, I don't understand why they would not have jurisdiction to apply for a search warrant and act accordingly. That sounds like somebody dropped the ball somewhere.
I agree.
Well, if we were to take it up, I'd like to understand better why the Attorney General's office couldn't get involved, why the Department of Public Safety didn't feel they could get involved, why the Agency of Natural Resources didn't want to be involved. I think that would help us to better understand. And you probably are correct, Joe, about explosives. You have to have a license, I believe.
Well, I think the people at Slate Ridge denied that there were explosions. The neighbors insisted that there were, but back to Joe's point about a search warrant to determine the matter. But I think, you know, overall putting in the bill was designed to try to get an understanding of why the current situation seems to tie everybody's hands. So even if we were to have some informational hearings on it at some point, I think that would help and maybe spur more action under existing law. But if everybody comes, what's that, Dick?
My understanding is we also have cases where the attorney for the town of Pollitt was threatened, where we have even reporters being threatened. So I think there's, it comes into the criminal threatening realm as well.
Yeah.
Because I I'm I, I, it would be helpful if we do nothing else than to clear up who's in charge, what agency, when the agency that oversees things like Act 250 doesn't feel comfortable in going in to enforce an Act 250 permit.
I agree.
Nothing else, that should get cleared up.
And I think it would be,
Senator White, do you have any thoughts on that?
No, not on that. I have something else, but no.
Okay.
the last thing I'll add is, I think it would be useful to have the administration state their position. Do they think it merits closure of Slate Ridge, given what they know, and are their hands tied, or do they support keeping it open? Because if they want to close it and they can't, we can help them. If they don't want to close it, then I think we're in a worse situation than we thought.
Are there appeals presently going on? I thought I heard there were.
Yep.
So,
I believe there are, yeah.
yeah. So, I mean, as I understood it in the past, we usually haven't interfered in a case where there are appeals going on. But maybe it's a totally different focus. So,
Well, I think if the focus is on enforcement of regulatory rules, like Act 250, then we need to better understand. I know at one time, and this goes way back, there was an effort to arm investigators for the Department of Environmental Conservation,
Right.
because they were getting threatened when they go to certain places. I mean, even a burn barrel, they were getting threatened by people. So that I can remember that. I don't know if either Eric and Michelle remember it or any other committee members, but that was an issue. I think Vince Aluzzi raised it when he was on the committee. So I think overall, that is an issue that we can obviously take up. If we can spell out to the administration what we're looking for.
mhm.
And Eric, maybe you could help us with that. With Mike O'Grady, maybe. Enforcement of environmental regulations where there's resistance, I guess, would be the topic.
Well, I think that's an aspect of it, but I think it's problematic that we've left it to the environmental side of things to regulate these operations, because I don't think that's what they're there to do. There happens to be an argument for environmental damage in this case, but I think it's more a case of if 2 or 3 other groups are watching Slate Ridge, realize that it can't be shut down, and they open similar operations, I don't think we want to be going further down that road. So clarifying how to stop them for what they are, not for incidental environmental damage, would also be a part of it, I would think.
I've got to take a 2-minute break. Did you take over for a few minutes?
Sure. Jeanette, do you
Thank
have-
you.
Well, I just was going to say that when Senator Sears mentioned criminal threatening, it reminded me that Senator McCormick has a bill on criminal threatening, and that made me think that we aren't going to know the full universe of the bills that we're getting until next week, because I think people have until Friday to get co-sponsors on bills.
Mhm.
And people are still getting co-sponsors on bills, which means that then they won't be introduced until probably next Tuesday or Wednesday. So we won't know until next week.
For some reason, I was thinking it was the 14th.
Well, that's what I thought, but then I remember Ginny said on one thing, do it by the 7th. So I'm not sure which it is. If it's the 14th, that's a real problem.
You have the memo from John Bloomer. Shall I go get
It's
it?
the 14th.
It is.
Yeah.
Yes.
That's a real problem because we could then be getting bills the week of the 17th, which is, I mean, that's outrageous. We should
Yeah.
tell people not to get co-sponsors, just to introduce the bills. Anyway,
Joe, I understand your arguments on the criminal threatening bill, and I think you're right in a certain way. It's just a really tough line to draw if it's only words without, significant actions, kind of like conspiracy in that way. Don't you have to have a significant action, or what's the language on conspiracy?
Yeah, I understand where you're going. Some
You
kind
have
of
to-
step in
Oh,
furtherance of,
one overt act.
yeah, you go.
Yeah.
There is already a federal criminal threatening bill of a public official that exists currently.
What
and I
triggered
thought
that, Alice?
TJ and the Secretary of State were actually working on something for us for this year.
Alice, do you know what triggers the, what do you have to do to
I
run
know
afoul of
that when I was I was the chair of the zoning and planning committee in Ludlow and received a threatening letter delivered to my husband's office. Not, the person left it in the door, and and another person on the board did also, and the FBI got involved to investigate it. So
Mhm,
there's something there. It was quite a while ago that this happened, but
mhm.
there must be something there that allowed them to get involved.
Yeah. Well, I'm not sure where Dick wants to go. I think he'll be back in 30 seconds.
I'm going to send a note to TJ and the Secretary of State, because I know that I got some information from them that they were working on something around this, because the Secretary of State's office was getting a lot of really, really threatening stuff. They played it for us, and it was scary.
Mhm.
Yeah.
Well, nationally, it's gone off the
Yeah.
charts.
Yeah.
And become routine with
Mhm.
members of Congress threatening other members of Congress. It's hard to believe that that's the standard now. So does anybody else have anything that we've yet to bring up in terms of your own hopes for where the committee's going?
I think with just a comment about Cheryl's bill on the guardianship, there's a lot in the proposal that needs to be examined with regard to the Disability Rights Act and what the unintended consequences would be in that bill if we go in the direction that it's going. I mean, it's a lot to sort out. It's not just an easy pass, I don't think.
Mhm. Oh, I was just going to say a word about another bill that I submitted for some constituents, and that's about aggregate values of crimes. So there in the Burlington, South Burlington area, maybe statewide, but certainly here, there's a kind of epidemic of shoplifting. So my sister works at Kohl's, for instance, and people fill carts.
Yeah.
And then Kohl's has a policy not to confront people. So they just walk out the door with a cart full of stuff, a car pulls up, and they drive away with it. And so some members of the Church Street Marketplace Committee came to me, and they think it's a problem that in the statute, there's a a relatively high bar for the value that you have to hit. It's $2,500 or something before the police are willing to respond in any significant way. So they were wondering if you could aggregate someone's thievery, if it's the same person or persons, and trigger penalties for them that way. So again, it's meant to introduce a discussion about how we can help retailers that are suffering hundreds of thousands of dollars in losses. And the pandemic seems to have accelerated it. So, so that's why that's in there.
There
And
may be some Rutland people very interested in that as well, because that was a
Yeah.
problem.
Yeah.
I don't understand. I know somebody who got dinged for stealing a pair of socks.
really here, the police really won't respond if it's, you know, $50, $100.
I'd be interested to hear from the state's attorneys, because individual state's attorneys, for example, traditionally depends on the retail theft and what it involves, what you're just talking about. But I know in some cases, it's not more than $50. The state attorneys but just said they don't want to even deal with it. In some counties, and in other counties, as Senator White just said, they may do a pair of socks. There's also selective prosecution in some cases where, you know, if it's a particular individual that has, you know, created problems, they may do that as well. But I think in general, it's that geographic justice problem that we have, and in certain counties, rules are one way. I know on counterfeit checks, they're the same. If you bounce a check, in some counties, there has to be a higher level than in other counties to prosecute even bother. So the police get blamed, but it's really the prosecutor's decision.
We don't have to
Well,
worry
it's
about
an
this. We don't have to
Huh?
worry about this in the kingdom because we don't have any calls.
Yeah.
And of course, we have the two most uniform prosecutors in Vince Aluzzi and Jessica Zaleski. So that,
Yeah.
if you want a classic example of different ways of prosecuting, have them both come in and have a chat.
I was under maybe I'm misunderstanding, but I understood the kingdom that the rule was you're guilty until found innocent.
No,
It depends on which county you're in and what the subject matter is.
I have to say that the kingdom is a lot more progressive in many ways than Windham County.
Well, anyway, those are both interesting subjects, Senator Bruce. It would be interesting. Who drafted that bill?
Which
I did.
one?
The retail theft.
Oh, that was Eric as well.
Eric. If we were to take that up, could we start with a memo asking the state's attorneys what their rules are in terms of the amounts? If there's certain areas where they don't prosecute, or are they selective?
You know, or is it chronic? I mean, it might be one person who's doing it every single day.
Yeah.
You know, that's,
Well, I mean, but they've had the problem out, you know, in other jurisdictions where you have these shoplifting gangs that go around and just
yeah.
hit high-end jewelry stores.
Mhm, mhm.
Might be something that we could ask Evan to survey the state's attorneys.
Yeah. Could we do that?
Yeah.
So, I mean, I think we are identifying a problem and another potential problem, but
Mhm.
I'm happy
Organize-
to raise that issue, Philip, or Senator Bruce. I think we need a little corral around to see if it's with the state's attorney and the and she's instructed the police not to do this, or if it's the police policy, maybe it's a different policy in South Burlington from Burlington.
Hmm.
I'd be interested, by the way.
I think
Can I
also,
ask a different question? Oh,
I think some stores have a policy, not saying Kohl's, but some stores have a policy that they don't want to have their clerks confronting people in terms of danger to them. So they just
Mhm.
roll it off and let the person walk out. Not on big shopping carts, but certainly in grocery stores. That's certainly, I've heard of that being the case.
But, and I've heard that there's certain retailers that are moving out of Burlington to other locations in Chittenden County, like LLB.
Exactly.
Senator White.
before we go, may I just ask, because we're right in the middle right now of judicial nominating, what the changes are, the potential changes that are being suggested in, I think it's 179. Do you know who drafted that?
Yeah, I did that one too.
I think that's Becca, isn't it?
It is. Do you
Yeah,
know
so-
what the changes are? I'm just
something,
curious.
Yes, the you know how now in the nominating process, the JNB is under statute required to send the names of well-qualified applicants to the governor. Right now, the number of names sent to the governor is confidential. But sorry, the number of names is public, but the names of the applicants themselves who are deemed well qualified is confidential. So a couple of the things that the bill proposes to do is it makes the names public. So the names who are sent up to the governor and deemed well qualified are not confidential, they will be public. And also you probably recall that, because it's happened a couple of times recently, or over the years anyway, that sometimes the governor will decide that the list that's sent up is insufficient for one reason or another, and ask for the JNB to reopen the process and send up another list of names. So the proposal would also prohibit that practice and require the governor to select from the list of names that's sent up by the JNB and not be permitted to ask the JNB to reopen the process and get more names.
Do we know why the suggestion to make the names public?
I think that's a question for the sponsor of the bill.
Okay. Okay, I'm just curious because we're in the middle of it right now. We're doing it Sunday and Monday, all day Sunday and all day Monday.
Ugh.
When I was on that committee, we had the situation with Governor Dean, and he wanted somebody else for Chief Justice, and the nominating committee sent him a list of names that didn't include who he wanted, and it was quite a battle between the nominating committee and the governor, and we ended up with Jeffrey Amistoy, who resigned as Attorney General and became the Chief Justice, and Bill Sorrell became the Attorney General. That's a little
We
bit
had
of
the
history.
same thing with Governor Scott 2-3 rounds ago when we sent up a list, and it was pointed out that the Constitution says from a list, but it doesn't say from the first list that's gotten there. And I think that they completely misunderstood the Constitution, but and there were 3 of us that fought against reopening it and sending up a new list, but we lost.
No, my recollection of the problem, governors
I mean-
went. Yeah, well, this was on the appointment of a Chief Justice, so.
Yeah. Well, this clearly says the Constitution clearly says from a list sent to the governor. It doesn't say from a list that the governor likes, but
Well, yeah. All right. Then that's an interesting. Are there other issues that folks, we do, can you talk to some of your House counterparts around spousal maintenance, Senator White, see if there's any point. Well, we do have S2 here,
Yeah.
which I think I introduced, and I'm willing to take it up again, but it just seems,
Yeah, I'll look and see who's on judiciary. I don't even know. Oh, I just spilled my glass of water, sorry.
oh,
Um, I don't even know who's on there right now, but I'll look,
all right, well, we can,
see if we can't do something.
yeah. I look forward to this session. I was looking forward to being in person, but
Yeah.
I think we all were to some extent, but my feeling still remains that no matter what, we should continue with a hybrid system. If we go back into session, I think most witnesses, and I personally would prefer to have no more than 7 people in the committee room. And so I think some senators may wish to be remote, and some witnesses will probably wish to be remote. And with limits in committee rooms, I still haven't figured out how you deal with somebody like the state's attorneys, the judge, others who are in 3 or 4 different committees on the same day. If you did a first come, first served basis for seats in the committee room, what would happen to them, who are your witnesses? But then they got to go up to House Judiciary either just before or just after. I think it just would be a nightmare.
I think you could limit it to the committee members, the staff, the attorneys, and the witnesses.
You'd be over the limit then.
Over in
But
our,
you'd be-
No, well-
in our room, if the limit is 7, and that's what's been established for Senate Judiciary, then once you had 5 committee members
Yep.
attend, and let's say 1 attorney, and let's say Peggy, you were at 7.
Right.
There's no room for witnesses.
Well, and also the press. I've never figured out, I mean, there's the concept of a pool reporter. So I
Yep.
suppose you could say you're going to have a pool report that'll be issued to the press. But if you're True North and there's already Vermont Digger in there, you can make the argument that the press is in there, but not your arm of the press.
Right.
So I don't see how you limit
Yeah. I don't know.
press.
But they have the ability to watch in real time. It's very different than when we just recorded it. They
Yeah.
can watch in real time now, so they could sit in another place and watch exactly what was going on, just as if they were sitting in the committee room. It's very different than
Yep.
when we just recorded.
Yeah,
Yeah,
I'm thinking
I
our
I
troubles
think that's
aren't
why
over.
we have to be, that's why we have to be hybrid, even if we go back into,
Mm.
people are in Montpelier.
and just to go to another piece of that, I think Joe made a very important point on the floor with regard to the type of test. I mean,
Yeah.
there's more information available about the tests, what they do, when they do it now than there was perhaps when the group was meeting. And I
Yep.
think that should be looked at with regard to more use of antigen
Well,
tests.
I
what do we
wanna-
mean by vaccination status too? Do we mean people that are boosted or people that are just with either
Boosted.
1 Johnson and Johnson or 2 Moderna or Pfizer?
Just so you're all aware, during the summer and the fall, when we were discussing this, I used my recollection from this committee's testimony about our lab here in Vermont having lack of resources, backlogs, et cetera. And I have to believe that the lab being used for this particular test is going to be facing their own backlog problems. As I understand it, it's going out to Massachusetts. But those labs are all inundated by people being tested for COVID. And they told us during the summer that it was a 3-day turnaround time, but I have to believe it's going to end up being longer than that. And in spite of everything I tried to argue, if you're walking around the building for 3 days, it makes no sense to me because you're defeating your own purpose, which was to block anybody from coming in the door in the first place. I was very frustrated, but that's the way it goes.
But, and so that, the way I understand the tests, and I've had a couple of the rapid ones, is that they test you to see if you're contagious right now. at this moment. And I think that's what we want to know is on Tuesday morning, somebody takes the 15-minute test. Are they contagious or not? I mean, I don't think we care if they had it a
12
week and a half ago, which is what I think the other test tells you, but whether they're contagious at that moment.
is what you
Any-
want.
Yeah, it's a compromise, but I think what they're, and I wasn't in any of those meetings, but it seems like it's mirroring the national strategy, which is Biden's administration says you either have to be fully boosted or fully vaccinated or be tested, and not tested every day, but once a week. And you're right, it doesn't make logical sense, but it's kind of a compromise, I think, between not testing at all or not giving people an option other than vaccination and doing nothing.
Yeah, I agree that you need to provide the option. Anybody who's vaccinated, boosted, they're not relevant to the conversation. The question is who's walking in the door that is not? And is there going to be a test that immediately tells you an answer to something, even if it's less accurate than the other test? Or are they going to take a test and not have the result yet and then walk in the door? That's really what it boils down to. And I told the various committees I was working with, I would much prefer to take some of this ARPA money and hire a full staff of people at the front door to provide an antigen test, which gives you an answer in 15 minutes, and hope that that was as accurate as we could possibly get it. But it made no sense to me whatsoever to have somebody walking in the door, even if they've taken the test and they don't have the result yet. That just is beyond my comprehension of wisdom, which is pretty limited, but that was my thought process.
Peggy, I think